Did you know that Elon Musk is being sued by a Twitter investor for securities fraud? I'm not talking about the Tesla lawsuit or the Tesla tweet. I'm talking about, did Elon Musk, as alleged by the plaintiff, delay his filing, his disclosure of his ownership stake in Twitter so that he could save himself $148 million on the purchase of additional Twitter stock? Or was it simply a filing mistake? So we're going to take a look at the lawsuit. I'm going to walk you through the actual complaint. We're also going to look at two disclosures that Elon Musk made to the Securities and Exchange Commission, which is the basis of this lawsuit. Hi there, I'm Michelle Hagan. I'm a legal analyst and a former prosecutor. You may recognize me because I provided a lot of legal analysis on the Elizabeth Holmes case. Yet another alleged fraud case, this time involving Elon Musk and a Twitter investor and potentially even more Twitter investors who sold their stock during a certain period of time. Okay, so let's take a look at the lawsuit that was filed just last week by a Twitter investor. Okay, actually, let me go to the lawsuit here first. So we'll scroll up, take a look at it. It's not that long. It's pretty interesting stuff, I think. So it was filed on, here we go, April 12th, last week, in the United States District Court, Southern District of New York. So that's federal court when we're dealing with securities law. Securities are dealing with stock ownership. That deals with federal law, so it's in federal court, so U.S. District Court. So the plaintiff is Mark Bain Rasala, and I apologize if I'm saying his name incorrectly. He's representing on behalf of all others similarly situated. And he's using that language because this is potentially a class action that he would be considered possibly the lead plaintiff on behalf of a whole bunch of other Twitter investors or people who sold their stock during a certain period of time and may have lost out on potential profit, which is what this is alleging. So it's a class action against Elon Musk for violation of federal securities law. The plaintiff is asking for a jury trial. And so they're alleging in this first paragraph here that on their personal knowledge and upon investigation conducted by the plaintiff's counsel and a review of documents filed by the SEC, which I will show you, and news reports and other publicly available documents, they're alleging the following. And again, just because a lawsuit has been filed, just because they're making these allegations against Elon Musk, doesn't mean it's true. They still have to prove this, right? If they go to jury still has to find these allegations to be true, all right? So, nature and summary, so this is basically laying out the facts. It's a federal securities class action on behalf of all investors who sold or otherwise disposed of Twitter securities, Twitter stock, between March 24th and April 1st is the class period that they're looking at. The filing was supposed to be made on March 24th, where Elon Musk was supposed to disclose. Okay, so Elon Musk is the founder of Tesla and SpaceX, richest person in the world, all right? Beginning paragraph 3 on January 2022, Elon Musk started buying a lot of Twitter stock. He started to acquire these shares beginning in January. Then March 14th, he acquired more than a 5% ownership stake in Twitter. In other words, he owned more than 5% of the outstanding shares of Twitter stock. And when that happens, you're required by federal law to file that disclosure telling the public, telling the SEC, that you are acquiring more than a 5% ownership in Tesla, right? I'm sorry, Twitter. In Twitter, not Tesla. Okay, that's another lawsuit. Paragraph 4 says that according to Section 13D, that Musk was required to file Schedule 13 within the 10 days of passing that 5% threshold. Well, if he hit it on March 14th, 10 days is March 24th. That's the deadline. That's when he was supposed to have filed this Schedule 13G is what it's called. So, paragraph 5, Musk did not file Schedule 13 with the SEC within the required time. This is all what the plaintiff alleges, and instead continued to amass Twitter shares. In other words, he didn't file the disclosure that's required by law. He kept buying the shares of Twitter stock. He kept buying more and more Twitter stock. And then he eventually acquired a 9.1%, clearly above the 5%, a 9.1% stake in the company before finally filing Schedule 13 on April 4th, 2022. And I'll show you that. Let's take a look at his filing that he made. So here is the initial filing, because there are several. They've amended it several times since this, but here it is. Here's the initial one. Here's what triggers the plaintiffs alleging that it was filed late, okay? So it says Schedule 13G with the Securities and Exchange Commission regarding Twitter. March 14th was the date of the event. That was when Elon Musk acquired more than a 5% ownership. So the clock started March 14th. And when did he file this? What was the date that he filed this? You can go ahead and read this. It says Elon Musk is the reporting person, right? He's the owner of the shares of stock. He had acquired 73 million shares in Twitter. That's a good day. He acquired 9.2%. It says on future filings 9.1, but we'll go with 9.2%. Ownership, he acquired 9.2% of the stock of the outstanding shares of Twitter. So he's a 9.2% owner of Twitter. Stock owner, right? You can go ahead and read this. It's about Elon Musk, where he lives, Austin, Texas, blah, blah, blah. Talks about his ownership. Under item 4B, it says percentage. He had 9.2% of the common stock outstanding in Twitter. You can read the rest of this, not applicable. Okay. Then he signed it and dated it. And I'm sorry you can't see the signature line, but it would have been here. It is, you can take my verification. He did sign it, Elon Musk. But it was dated April 4th, right? This was supposed to be filed by March 24th. So this looks like the plaintiff has proved, just based on this one document, this Schedule 13G, that Elon Musk didn't file it on March 4th. He says, after reasonable inquiry and to the best of my knowledge and belief, I certify that the information set forth in this statement is true, complete, and correct, dated April 4th. So he blew the March 24th, right? Was it a mistake? Was it fraud? Why did he do that? What happened? But this document tends to show that the plaintiff has proved that Musk filed it late. He didn't file it. He blew the law that says you have to file it by March 24th, right? Mistake. Maybe it was on purpose. Maybe it was fraud. We're going to find out. Or actually, the jury will make the call. But let's see what else the plaintiff alleges in their lawsuit. So looking at paragraph 6, when Musk finally filed it, he revealed his ownership stake. The company's shares rose from a closing price of $39.31 per share on April 1st to close at $49.97 per share on April 4th. In other words, once Musk disclosed that he was a 9% owner, the shares shot up 27%. But this plaintiff and potentially other plaintiffs who sold during the period of March 24th to April 4th, I think it's April 4th or April 1st, I think they say April 1st, whoever sold, and if you sold your stock during that time, you may be part of this class action. You may be considered a class member because they lost out, right? Here are the damages. We lost out on 27% profit on each share of stock that we sold because Elon Musk failed to disclose that he was an owner, and had they known, I'm sure they allege, and they do allege. Had they known, they wouldn't have sold because they wanted to ride. They wanted to capitalize on that profit. Once the public knew, they'd invest in Elon Musk, right? They'd invest in Twitter. I think that's what they're alleging. All right, so paragraph 7. Investors who sold shares between March 24th and April 4th missed the resulting share price increase. They lost out on the 27% profit. By failing to disclose in paragraph 8 his ownership, Musk was able to acquire shares less expensively. Well, these investors, who sold, lost out on the 27% profit, but Elon Musk, he bought at the reduced price, right? Because the public didn't know yet. So he got it less expensive, right? He bought it at a cheaper price. Once the public found out, the price shot up. That's the $148 million that he saved. That's what the plaintiff alleges. Throughout the class period, defendant made materially false and misleading statements. Okay, we're getting to the fraud. And admissions by failing to disclose to investors that he acquired a 5% ownership stake in Twitter. Paragraph 10, the federal law claims asserted. Paragraph 10, 11, 12, 13 all deal with jurisdiction and venue. It's federal law, federal court's the proper venue. The jurisdiction is New York because that's where the New York Stock Exchange is and where these Twitter shares were traded on the New York Stock Exchange. So that's what they're alleging here. The parties are the plaintiff, Mark Bain Rasala, against the defendant, Elon Musk. And then this is basically saying again that Elon Musk, because of his position as a 5% owner, was obligated by federal law to file that filing that I just showed you, the Schedule 13, on time, and he didn't. He filed it April 4th. So what is that, 11 days late, if I did my math right? And during those 11 days, guess what Elon Musk did? He bought a lot of Twitter shares, and I'll show you that. So you can go ahead and read these. These allegations, basically what I've already talked about. I'll just scroll through. You can go ahead and read this. Then they're alleging it's a class action. This plaintiff is bringing this action on behalf of a whole bunch of other potential members. Anyone who sold their stock during that class period of March 24th to April 4th, if you sold your stock, you might be a class member if this case gets certified. It has to get certified as a class action by the court. All right, you can go ahead and read this. But they say the class doesn't include Musk. He's excluded, right? He's the alleged fraudster. So the members of the class are so numerous, they don't know who they are yet. They don't know how many. But the plaintiff believes that there are at least 100 or 1,000. Thousands of members that may have sold their stock during that window of time. Millions of Twitter shares were publicly traded during that time. So through discovery, they'll figure out who those people are. Who those shareholders are who potentially lost out on 27% profit per share. All right, and then they talk about well-defined community of interest. This is all the stuff that they have to allege in their complaint. Whether the defendant violated the Exchange Act, whether the defendant admitted or misrepresented material facts. He knew that he was presumably, allegedly, above the 5% threshold. I assume he knew he had to file. I assume, right? Was it a mistake, or did he do it because he was going to buy a bunch of shares of stock at a reduced price? I don't know. We're going to find out. So the plaintiff also says whether the defendant's statement omitted material facts, whether the defendant knew, did Elon Musk know or recklessly disregard that his statements were false and misleading, whether the price of Twitter securities were artificially deflated. I mean, what was going on? Was he making public statements during that period of time? March 24th to April 4th, did he make public statements? When the public didn't know that he was increasing ownership, did he make statements that can be considered misleading or materially false? And then in paragraph 29, plaintiff's claims are typical to those of the class. This is stuff that they need to allege to get it certified as a class action. And that the class sustained damages from defendant's wrongful conduct. The plaintiff will adequately protect the interests of the class, and the plaintiff has no conflicts with those members in the class. And a class action is superior than any other remedy, any other available methods for fair and efficient adjudication of the controversy. So in other words, it can be just Mark Rosala versus Elon Musk, but because there's so many other potential investors who may have sold and did sell their Twitter stock during that window of time when Elon Musk was supposed to have disclosed that his ownership in Twitter was increasing, that this plaintiff can represent all of and the plaintiff's counsel can represent all those investors who lost out on that potential 27% profit. That's what they're alleging. They also talk about fraud on the market. You can go ahead and read this. No safe harbor. You can read that. Causation is always tricky. You know, did the investors lose out? Did the stock price shoot up because Elon Musk was buying more shares in Twitter, or was the price increasing because of market expectations or because of some other factor? So in this case, the plaintiff has to show that the damages were due to Elon Musk's failure to disclose his ownership stake. So as a result, individuals who sold their shares of Twitter between March 24th, when Musk should have filed Schedule 13, and April 4th, they did so. They sold their stock in Twitter at artificially deflated prices and were damaged. They lost out on that 27% profit per share. Then they talk about scienter. These are all the allegations they have to put in their complaint. And here's where they say, defendant Musk saved approximately $143 million on his Twitter purchases because he was buying at the artificially deflated price before the public knew. Then they talk about count one. Simply, it's count one. He violated the Exchange Act. During the class period, defendant Musk disseminated or approved of false statements which he knew or deliberately disregarded were misleading, and that they contained misrepresentations and failed to disclose material facts necessary. That Elon Musk was a more than 5% owner. And they claim in paragraph 41, they allege that he employed devices, schemes, and artifices to defraud. He made untrue statements and material facts or omitted material facts. And he engaged in acts, practices, and a course of business which operated as a fraud and deceit upon those who sold Twitter securities during the class period. Plaintiffs in the class suffered damages on reliance on the integrity of the market, relying on the filings that were made or not made, right? They were not made in this case. They were made late. And they lost out because the market prices were artificially and falsely deflated by the defendant by Musk's misleading statements, allegedly. This is what they're asking for. Here's their damages. Number one, we want to be certified as a proper class action. That court has to decide that. Number two, they have to certify the plaintiff is a lead plaintiff. They call them lead plaintiffs in class action, right? And again, that has to be certified. And this is where the challenges will come in. These are the pre-trial challenges to this going to trial, is that maybe they'll try to say that this plaintiff doesn't represent the class, or they haven't made the certification requirements. Again, that's up to a judge to decide whether or not to certify this as a class action, or whether it's just going to be one plaintiff, Mark Rosala, against Elon Musk. And the plaintiff is asking for the appointment of the plaintiff's counsel to also represent the class, and they're seeking compensatory to be made whole. In other words, to get the 27% profit or whatever damages they prove, plus punitives, right? It's fraud, so they want punitives to deter, if the jury finds this, to deter Elon Musk from doing this again. Punitive damages, punitive, okay? And to award the plaintiffs their costs and expenses for pursuing this lawsuit, including reasonable attorney's fees and experts' fees, right? So this is kind of, plaintiff's counsel will take these kind of cases because if they win them, they get their attorney's fees, right? And their costs and the experts. And again, this is going to be, if they get there, right? Because these cases typically settle. I mean, really, I think this case will probably settle, but I don't know. I mean, he still has that Tesla case going on, so we'll see. But, it's expensive. These cases are expensive to pursue. They're going to have expert witnesses, especially to, the item of causation, whether or not, what was the share price, whether or not the market moved because of Elon Musk, or whether it had something to do with something else, okay? And they're asking for trial by jury, and it's signed by plaintiff's counsel here, Jeffrey Block, on April 12th. So that's the lawsuit. And now let's look at one of the other filings, which shows you, and I'm going to take you up to the top here. So this is a filing that was made. It's an amendment to. So their amendment to the filing I just showed you, the initial one where he filed it on April 4th. This one was filed on April 4th as well, but there's a few things that were added. So let's take a look. So it says here, they previously filed a statement to Schedule 13G, which is what I showed you. Elon Musk is reporting on this one. This is Schedule 13D. It's an amendment to the 13G filing. So it's a filing after the initial filing. Elon Musk is the reporting person. He's saying again, he's got 73 million shares of Twitter. He's got a 9.1% ownership stake in Twitter. Look at paragraph 13. Says that, he previously filed the statement 13G on April 4th. Okay. And then let's look at, this is where he has to indicate he's the reporting person under item 2. His principal business is in Austin, Texas. They talk about whether or not he's had any criminal proceedings. He hasn't, according to D. Paragraph E is interesting because it mentions the Security and Exchange settlement in the U.S. District Court in Southern District of New York, same court, on September 2018 and 2019, relating to the August 7th tweet that he made regarding Tesla going private. And what is he trying to do here? He's already, I think you may know, or I might have a moment to do a video on the offer that he's currently made to Twitter to buy it outright, 100%. Right? So when he went into Twitter, when he invested over $6 million, I think it was 2003, he didn't start Tesla. He went in and bought 6.6 million, I think, shares of Tesla, and then slowly acquired Tesla. Right? And this looks like what he's doing here with Twitter. He's buying and buying shares, and I'll show you that. He's asking to take it private. He wants to take Twitter private to make the changes he wants to make. And, when I get to that offer video, it'll be interesting because you'll be able to read the emails and the offer that Elon Musk made to Twitter. Okay, so let's look at, and this relates to it. See item 4, on April 4th, Musk and the issuer, that's Twitter, entered into a letter agreement where Twitter will appoint Musk to the board of directors as long as Musk does not acquire more than a 14.9% stake in Twitter. They don't want him to take over Twitter, right? So they're limiting. You can go ahead and buy more shares of Twitter. We'll put you on the board, but we're capping you at 14.9% ownership, right? They don't want to have a takeover. So let's look at what he was buying. And again, the shares of stock are held in his revocable trust. It's Schedule I. Schedule I. He filed this on April 5th, the day after that initial April 4th filing. He filed it and certified it was true and correct statement. Here's Schedule I, which shows you his purchases of Twitter stock. Beginning January 31, 2022, he started buying 620,000 shares. February 1st, he bought 542. February 2nd, he bought 850,000 shares. February 3rd, 3.6 million. February 4th, 1 million. February 7th, 4.8. You get the drift. He was buying basically every day. Millions, if not hundreds of thousands, shares of stock. Okay? Then we get to the important date of March 14th. And please don't mind my scribble here. 9%. That's when on March 14th, he had acquired 9% ownership in Twitter. He had acquired over 5%. That threshold was triggered. He had acquired over 5% ownership. So therefore, the clock started. He had 10 days to disclose. And it was due March 24th. And what was he doing between March 14th and March 24th? He was buying millions of shares of Twitter. March 14th, he bought 2.7. March 15th, he bought 1.9 million. March 15th, he bought 1.9 million shares. March 16th, he bought 2.9 million shares. March 17th, he bought 1.5 million. March 18th, he bought 2.8, etc. March 24th, again, he hasn't disclosed yet. He bought 1.9 million. March 25th, he bought 3.4 million. March 28th, he bought 2.6 million. March 29th, he bought 2.8 million. March 31st, he bought 2 million. April 1st, he bought 2.1 million. This is all during the time in which he should have filed. And look what he was paying. He was paying $33 to $40 a share. But if you look at the plaintiff's lawsuit, they said it went up to $49 a share. So if you do the math here, and that's probably how they came up with 148 million, because they allege that Musk did not disclose, did not make that filing that he was required to by federal law, and took advantage of these deflated share prices and bought millions and millions of shares. And here it is, Schedule I. So, what do you think? Do you think it was a filing error? $148 million filing error by Elon Musk? And again, this is just my opinion. You look at when he was buying the stock, you look at the price. He had a duty to disclose. He didn't disclose, but he's buying millions and millions of shares of stock. And then we find out that he's made an offer to purchase Twitter outright. He didn't take the seat on the board, as far as I know. He doesn't want to be limited to the 14.9% ownership of Twitter, it looks like, right? Is he trying to buy Twitter outright and take it private? Where have we seen this happen before with Tesla? I don't know. Is that what he's doing? I don't know. So you tell me. Please leave a comment, leave a question. You make the call. I want to know what your analysis is. Do you think this is just a filing error? He forgot that he blew the deadline? Or do you think he withheld? He made material misstatements or omissions. He committed fraud. And that he was able to buy shares of stock at a reduced price. And that these plaintiffs and these potential class members have lost out on that 27% profit on each share. It's not going to be an easy case, but it's probably most of the time these cases are settled, right? Assuming he's made the 148 million, what's the cost of settling this lawsuit? I don't know, just my opinion. But that Tesla case is still going on, so I don't know. That's up to the plaintiffs and the defendants to figure out how this case is going to play out. And it's going to, if it makes it past, gets certified, it'll probably get certified, right? So then it'll be discovery. They'll figure out who else is involved, what the damages are, right? And if they go to jury, they have to prove it to a jury. So, again, I think these cases generally, most of the time, are being settled. So we'll see. So let me know. What's your analysis? Do you think it was a mistake or do you think this is fraud? So please do leave a comment. Please hit the like button. Got to hit that like button. Please hit the bell notification. And please do subscribe. Thank you very much for subscribing, to all of those of you who have subscribed. I appreciate you supporting my work. And if you haven't subscribed, please do. Thank you very much for watching.